I'm Céline Castets-Renard. I'm a law professor at the Civil Law Faculty, and this is my great pleasure to welcome all of you for this webinar on the role of standard in AI regulation. This webinar is co-organized by two research chairs and by the SCC Standards Council of Canada, the research chair, Wilson Chair in e-commerce law held by Professor Vincent Gautret, Université de Montréal, and the Canada Research Chair on International and Comparative Law of AI, which I have the honor to hold as a professor at the University of Ottawa. And the Standards Council of Canada is represented by Dr. Tom Lebrun, who is AI standardization policy lead. And this is our pleasure to welcome all of you. I would like to give you an overview of the program of this webinar. It will take place in English from 9 to 1 and will be divided in through roundtables, 1 hour and 15 minutes. And we will have 15 minutes break in between each panel. The three panels will be on geopolitics of standards, substance of standards, and governance and institutional approaches to standards. And each of them will be chaired by me, by Professor Vincent Gautret, and Dr. Tom Lebrun. Having said that, I will start the first panel on geopolitics of standards. And I would like to give you a few words just to give you, just to set the stage regarding this topic and to introduce our two wonderful panelists after that. Just to remind of all of you that AI standardization refer to the development and adoption of shared technical norms that govern the design, deployment, and regulation of AI. While often presented as a neutral technical process, AI standardization is deeply embedded in political and geopolitical power struggles, reflecting the interest, values, and strategic goals of different nations and regions. And our panel will explore the geopolitical dimensions of AI standardization, including power dynamics, regional approaches, and international influence. And regarding power dynamics in the context of the global AI race, it means that standards exert several forms of influence: economic power, technological sovereignty, and normative hegemony. And we also see that the national and regional approaches can embed different visions of AI standardization and AI governance. For instance, in the US, we can see a favor for market-led innovation and minimal regulation, trusting the private sector to lead through, for instance, American National Standards Institute or National Institutes of Standards and Technology, NIST. And in China, we can see a preference for standards often support, most often centralized control capabilities. And we can see the influence of China in the International Telecommunication Union. And in the EU, in European Union, we can see a rights-based and precautionary approach and the protection of fundamental rights through the AI Act and the presumption of conformity based on the Sentinelec AI standardization. But this is probably a too caricatural vision of the different dimension, regional and national dimension. And we also need to consider the expression of convergence and influence into international organization, such as, of course, International Organization for Standardization, ISO, and the Institute of Electrical and Electronics Engineers, IEEE, and International Telecommunication Union, ITU. And of course, Sensenelec is also a geopolitical arena of contestation of dominant states. To sum up, we can see that we already have a lot of struggles and a kind of competition, a normative competition, and not only an AI competition. And to discuss these topics today, these issues today, I'm very glad to welcome Professor Pierre Larouche and Professor Marta Cantero Gamito. And unfortunately, I have to tell you that unfortunately, Marion Audac cannot make it today and cannot be with us today. But we will have a very interesting presentation, I'm very sure of that, of Pierre Larouche and Marta Cantero Gamito. We will have first Pierre Larouche. Pierre Larouche is a professor of law and innovation at the Faculty of Law of Université of Montréal, Université de Montréal, Ivado researcher and fellow at CER, TILEC, and at the George Washington University Competition and Innovation Center. His research centers on economic governance and, in particular, how law and regulation struggle to deal with complex phenomena such as innovation. He has been writing on standardization for more than 10 years and lately, and he has been working on AI governance. In his talk today, Professor Larouche will present the geopolitical landscape of AI governance to discern the main challenges. He will assess if and how standardization can contribute to addressing these challenges. Pierre, please, the floor is yours, and this is a very great pleasure to have you today. Thank you.
Thank you, Céline, and welcome everyone to this conference. So I will first put my slides on the screen, if you give me a moment. That should be it. There we go. So I will immediately revisit some of the issues that Professor Castets-Renard mentioned in her introduction. And the presentation I'm going to give is based on work I've done on standardization, the main co-author being Professor Justus Baron, who will speak later today, and work I've done more recently on AI governance. So the challenge was putting it all together. So I will talk first about the geopolitics of AI governance, then and now, the perspective of firms. Then we'll look at what's the worst case scenario, what are the governance challenges, and then at the end move on to see how standardization fits in all of this. So I'm going to take you first to the distant past, a long, long time ago, in 2024, and look at what the situation was then. So we had essentially, I would say, three reasonably well-articulated approaches to AI governance. Certainly the clearest one was the EU approach. And the EU approach, as we all know, involves a piece of legislation on AI horizontally that has been passed, and it's in force and it's being implemented, the AI Act. And the AI Act fits within the EU approach to product regulation. So it has its set of substantive principles, especially on high-risk AI systems and general purpose models. There's a compliance system, which looks like what we do in the EU on product regulation. Of course, it makes room for standardization, as is customary in EU law, with the effect that is given to standardization, a presumption of conformity. And by and large, I think I've written about this as an attempt to draw firms on a path to being responsible firms in their AI development and deployment. And we saw Canada at the time trying to follow on the EU footsteps, but of course, Bill C-27 was never adopted, and we'll see. I would suspect that the new government we'll come back to this probably next year, which gives us the benefit of learning from others. The second big approach that was also reasonably well articulated was the approach of the UK, Japan, and Singapore, as well in other countries, whereby these countries said, well, we're not going to intervene the way the EU does, no legislation. Let's do it bottom up. So let's work with the firms, talk to the firms, issue soft law instruments as needed. So an approach relying on industry-driven self-regulation or co-regulation if the state is a bit more active. Okay, the UK has moved a little bit away from this, but it's still very much the Japanese and the Singaporean approach. Next to these two approaches, the Chinese approach is less clearly articulated, but still at the time, it was relying on a sectoral and more thematic intervention. So no horizontal legislation, but legislation on and intervention on certain topics, the main one being generative AI, but other topics as well. And of course, a relatively strong proactive industrial policy. So in 2024, which seems a long time ago, the US was kind of somewhere in between. Close to the EU on substance, the Biden administration shared a number of views or a number of principles with the EU. Close to the UK and Japan on the institutional approach, the US was reluctant to legislate. There were plans, but as we know, Congress is not able to legislate very much these days. More thematic focus, a bit like in China, and not a strong need for industrial policy at the time because the US was in the driving seat anyway. So the US last year was the one country that was kind of pivoting and maybe swinging towards one or the other model. So what happens since then? Why has it changed? Well, in the EU, we've had the Draghi report in the fall of 2024, where Draghi essentially tried to change the course of EU policy, pulled the alarm and said, look, we're already not that great on AI and it's not going to get better. Our approach is too heavy, too top heavy, and overbearing, especially on smaller firms. And that message, of course, has made it to the desk of the new commission, von der Leyen too, and they've indicated, yeah, we will. We're not even done with the first round of implementation of the AI Act. Many things are still not developed. We're missing a lot of implementation instruments, but already the EU is saying, well, we will fiddle with the act. We might have been too interventionistic. In China, the big change is DeepSeek came to the fore earlier this year, so it's still, there's some discussion and disagreement as to exactly what it is that DeepSeek did, but most people say, it showed that you can do serious AI without the same type of resource commitment as the big US firms are having, which of course changes the game at industry level. And all of a sudden, if shows that China is up to something, and their approach seems to be working. And in the US, of course, we get a new administration. And you will remember on the first day when Trump signed the pile of orders, one of them was to cancel Biden's executive order on AI. So right now, things have shifted. So the US approach is now a bit clearer. It's no longer just navigating. There's been a fairly clear rejection of an approach that would involve a stronger regulatory intervention. I mean, the Biden order was essentially, if you looked at it, housekeeping, trying to direct the various departments of the US government to do something. Now there's nothing left. But it would be mistaken to say that there's no pressure on the firms. So there's this stronger industrial policy focus that we heard from Vice President Vance, but I was myself in the room for some policy speeches by the new leaders of the antitrust authorities in the US, and they, of course, keep the pressure up. And that is a policy now Google is before the courts, Facebook is before the courts, and this is now being conceived as part of the broader antitrust policy of not allowing the large firms to run away with the AI market. So it's no longer seen as a question of risk regulation, but rather a question of keeping the market open and maximizing the opportunities for all of the US AI industry. China, of course, reacts to the US approach, sees it as being a bit hostile, understandably so. And then I discussed with a couple of colleagues this digital empire scenario, which is now coming up, that we would have two big entities. For the US, Japan, and Singapore, this changes the picture in the sense that these are all countries. I haven't spoken to people in the UK and Japan, but in Singapore, it's clear, and it should be clear in Canada as well, where these are all countries that are not going to be digital empires, but are not so keen about being a satellite either. So they're kind of, I don't know if it's the right image because it has its own political content, but it's kind of a non-aligned bloc that is emerging. So countries that would like to keep things as they are, so keep a fair amount of global exchanges of trade and openness on AI, because that's their best scenario. And I think Canada would fit in there, and I'll be curious to see what we decide to do next year. And this time it's just a year ago, the EU had the clearest approach. Now it's the EU that has the problem of trying to fit in this new puzzle. And the big question, I think, is does the EU want to become a digital empire on its own? Can it become a digital empire of its own? Because they are running behind. Or is the EU going to say, no, we put our bet on we try to fit with the UK, Japan, and Singapore. We're going to drive the non-aligned bloc, in which case probably there's going to be a lessening of the regulatory pressure. So that's my picture of the geopolitics right now. But there's been a big shift recently, and then there's every reason to think that it will continue to shift because this is fast moving. Now, from the firm's perspective, where does that leave them? Are they caught up in these geopolitical games? To what extent are they? Well, there are some interesting things to note about AI, and it's been noted. It is a technological wave that, if you compare it to what we saw 30 years ago with the internet or with mobiles and so on, the state doesn't have a lot of pull on this. This is not state technology. It's not the Department of Defense or whatever institutions in the Chinese state that are driving this. These are private firms. So it's a technological wave that's mostly in private hands, which makes it complicated for the state. Now, it's hard to say where the technology is because this changes rapidly, but the discussions I have with the technologists, they say, well, we're not done yet with the evolution of AI, and the current model is there's a very clever algorithm with large language models, but there's a strong element of brute force. It works because we put massive amount of resources in harvesting all the data and in the hardware. We've all read about the NVIDIA processors and the amount of energy that is needed to run the current models. So it's not necessarily sustainable. And then we have these firms that are leading, and they originate mostly from the high-tech sector, like OpenAI, Google, Meta, DeepSeek in China. And their innovation culture is mostly in line with what I call a permissive regulatory approach. That's the approach that governs the high-tech sector for as long as it has been there, I think, since the 70s and the 80s. And in terms of law, these are all industries that evolved through all the technological ways in a context where they typically had no need to get an authorization before putting their product on the market. They had no constraints coming from regulatory definitions. They didn't have to fit their product within the definition of like pharmaceutical companies. They must produce a medication or something that is not a medication, a medical device, class 1, 2, 3. They have never been playing with these definitions. These are firms that come up with an idea and essentially they bring it to the market and they're subject to the laws that are applicable to everything around us, but no specific regime for them. There's one thing in which they have an exception, though, and it's in respect of civil liability. So these are all firms that are used to not being liable for much, if anything. And then this is a policy decision. This is not something that is written in the sky. It's a decision that we took 25 years ago to help the digital sector. But having evolved in this legal context, they have this culture of essentially move fast and break things, that is, as it is always said. And these firms are difficult customers, if you want, for public authorities. So yes, they're caught up in the geopolitics, but they are firms that are not used to being led by the states and told what to do. So the worst case scenario, if you look at all of this, is that we would have AI controlled by a small number of firms, so the firms that are currently driving the technology. And these firms then control the AI development path. And they will say, well, trust us on the risk. We know what we're doing. And here's, we're very innovative. Here's the innovation. But they do serve their interests first and foremost. So we will get the innovation, that these firms want to bring to the market. It will certainly not cannibalize their own interest. And it will reflect the games that are being played in the industry, the quest by some people, because some of these firms are very much led by a single person, the quest by people for artificial general intelligence and their reflections about humanity and so on. But this is part of this worst case scenario is these firms with very, a small class of controlling actors decide what is happening. And then public authorities have limited control over private firms, as I mentioned. So we have digital empires, but they could very well be digital empires in the sky. We think that we control something, but we actually do not. So there are two key challenges that arise from this. So how do you want to avoid this? The first challenge is to increase the traction between the firms and the public authorities. So give us a little bit of grip, over the firms. And this implies that the firms must be brought to engage into policy debates, to think, you're not the master of this, you're not deciding. There are public policy concerns that you should be dealing with and not just waiting for the state to eventually come and tell you. And on the side of the state, of course, there needs to be a commitment of resources to become a meaningful actor on the scene, to understand what is going on with the industry and do something. So some kind of dialogue must be put in place. And then on the other side, and here I think it is actually good news to see where the US is going with the extra emphasis on antitrust. You need to do something about industry concentration, and this will involve legal work, a lot of legal work. So competition law, IP law probably will have a role to play in this. There's some industrial policy, research funding also. I think it's crucial that the state uses its resources to keep research alive outside of the large firms. So that there's a big agenda, a governance agenda. What makes it really interesting, I think, from my perspective as a researcher, is of course that these two objectives are in tension. So the more you create friction and traction between the firms and the public authorities, of course, this strengthens the club. At the same time, you don't want to have too much of a club. You want to have newcomers and diversity. And the small startups are typically not firms that you control so well from a point of view of risk. So they might actually be increasing risk, but they're small firms. So, that's where we are, I think, and there's a lot of work to be done still. So that brings me then to standardization in all of this. So we've seen it's part of the EU policy, as is always the case in the EU. The US has invested in standardization. Chinese actors are also present, and AI standardization so far, as far as I understand, ISO and IEC, of course, are a prime place because they are the ones who are supposed to get the mandate to standardize. Certainly, the EU mandates have been given mostly to CEN and CENELEC, and they fit within the ISO IEC structure. If you look at what standards are starting to be popular, the NIST standards are actually more referred to. And then there's a big amount of work done at IEEE as well. But still, this is tough for the standard organization because we are dealing with different objects. So traditionally, when you had standards, the industry came together, there were competing solutions, and you needed to say, well, no, this is going to be the standard. This is the shape that the power plug is going to take, or this is what we're going to do for quality control. There are three approaches. This is the one that we're going to take. Now, more and more, standard setting is about the firms coming together to build a solution. There's no choice to be made. It's rather of a building exercise, which is more complicated. Standards used to be very detailed technical specifications that no one really wanted to get busy with. And now they're becoming more general statements. And it's something that I'm sure we will hear today that they're very general. They don't actually give you so much direction. They just set a framework or give you general statements. There used to be this strong distinction between two categories of standards, ones on product safety and the ones on interoperability. That distinction is becoming blurred. The standards more and more touch upon both aspects, and both aspects are intertwined. And last but not least, standards used to have very little public policy dimensions. I mean, if you look at the big effort that was done to develop the standards for mobile telecommunications, 4G, 5G, and so on, the usual game was, as long as the machines are safe, that they don't injure humans, and that the network can run with whatever handset is connected to it, and the network doesn't go down. That was it. The rest was a technical solution. So the public policy element was relatively limited and clearly understood. When we're talking about standards on AI explainability, this is different. And there's much more public policy. And of course, it makes the task of the standardization bodies much more complicated. So it places the standardization bodies, ISO, IEC, and so on, it places them in a position where they have difficulties in their relationship with the public authorities. Some of these difficulties are long-standing, so there's always a problem of access to standards. We will hear about this, I'm sure. Because there are more public policy issues, there are interest groups that are mobilizing, and they do make a lot of noise, but sometimes they argue about legitimacy, they make claims to be included, and so on. I'm not sure that it's always productive or improving the quality, but it's way more present than it used to be. And it makes the relationship with public authorities more difficult because there's more debate around public policy issues, which means that the approach that was used so far with standards, which is legally speaking a mostly procedural approach, as long as certain procedural conditions are fulfilled, we're happy with the product. That was more or less this approach is increasingly untenable because it's less and less possible to say we don't care what's in the standard as long as the conditions under which it was drafted were correct. And on the other hand, what we see is the leading firms in AI, they're not that invested in the standards development either. I mean, the main club that they have been active with is the Club of Mobile Communication Standards, and that club, so ETSI, 3GPP, and so on, has been sidelined at the start. Now they're coming back, but originally they were more sidelined. ISO IEC is actually, is based on local standardization bodies in each country, which traditionally haven't been that present in the digital sector. And the IEEE group on AI, it doesn't, it has grown largely of a concern with AI ethics, and I'm not sure that it connects so closely with the firms themselves. So the standardization bodies have a difficult time because they have difficulties in their relationship with public authorities, and they need to make sure that they have the firms on board. So what do we see? There's a risk of fragmentation for sure. I mean, if the geopolitics takes over standardization as well, then maybe the geopolitical effects will prevail, and we will have standards on AI that apply in the EU, others for North America, others for China. This is, of course, not a very happy prospect. There's a risk of irrelevance also, that things are simply not done at, or standards are written, but they actually are not used. Are there any alternative on hands? Well, the EU tried with, and I see Professor Castets-Renard smiling. Of course, I will not say much because she has more to say and more experience with this. But the EU had this code of practice exercise for general purpose models, which I think was partly born out of a concern that standards would not deliver, that the procedures would be too long, and we might not get the type of deliberation that we want. And I think it has proven it has proven difficult to set up another procedural avenue, another forum that would make up or correct the perceived shortcomings of standards. So it's not that clear that we have an alternative to standardization. So I personally believe that standardization still offers a good path to solve those governance challenge, sorry. They're not just a front for private interests. I think that's going to be part of our discussion today. My belief personally is that their history of standardization shows that it's not always been driven strictly by the interests of large firms. It's mostly driven by the profession, by engineers, by technologists. The sociological evidence is also that when you put all these people who are specialists in AI in a room, their common interest on the technology sometimes prevails over their interest as towards their employers. And the economics, the structure of the standardization body is actually made to try to put a damper on strict commercial interests of firms. And I think there is considerable evidence over time that standards development has evolved into a forum that is not just about firms fighting it out. It generates another type of discussion, and the legal framework, I think, reflects this. It's a forum where the industry, the authorities, other stakeholders can meet, but they do need to commit resources. I think the big problem that we see is that there will always be lots of resources from the industry. That's where the knowledge is. And when we try to make standardization bodies more representative, we bring other people on board from public authorities, from stakeholder groups, and so on. They have difficulties with the level of expertise, and there's a tension. I think it's very good.
I would ask you to go to your conclusion, please.
Yes, sorry. I was told there was more time, and I did it a little bit more slowly. Anyway, so I think the standardization will remain a key government and should remain a key government in AI governance, but it's together with the framework. So there needs to be a clear statement of substantive policy principles to guide standardization work, solid regulatory authorities to be able to make the call, is the standard good or not? robust competition law enforcement, of course, and investment in alternative research venues. So thank you, and sorry I took a bit longer.
This was really perfect. Thank you, Professor Larouche. You have very well setting the stage. And now this is my great pleasure to welcome Marta Cantero Gamito. Marta is a research fellow at the Florence School of Transnational Governance, the European University Institute, and professor of information technology law at the University of Tartu in Estonia. Her research focuses on the regulation and governance of technology, with a particular emphasis on transnational private regulation and standardization. Her presentation today will focus on the following question: how do geopolitical dynamics influence AI governance, and what roles does the EU actually play in shaping standards? Thank you, Marta, for being here, and please, the floor is yours. Thank you.
Thank you very much, Céline. Thank you, everyone. It's absolutely my pleasure to be part of this conversation today. And I very much appreciate Professor Larouche's intervention on AI governance, because he has really set the stage quite well on some of the issues that I'm going to touch upon. So, as Professor Castet has mentioned, I am focusing on the geopolitical dynamics in AI governance through standardization, mostly focusing on the role of the EU in all of this. So it fits very nicely as a follow-up, and even though you may believe it or not, we haven't really coordinated on this, so it really works really well. My first point of my presentation is 4 points and some concluding remarks. So my first point is about AI standardization as a geopolitical project. So here I'm going to allow myself to remind to those of you who are not very familiar with standardization, what are the specific functions of standards that Professor Larouche has already mentioned, and I'm just going to try to bring them together. So Professor Larouche very nicely mentioned that usually standardization has been used for 2 purposes. One could be like interoperability, and the other product safety. So those are the main 2 functions of standardization: to make systems communication interoperability feasible. So this is about like the technical compatibility, but also like about, in some instances, and more so in the case of AI, this conceptual feasibility, right? So how the technology communicates with each other. But in the context of product safety, technical standards are actually an instrument of market regulation. So technical standards actually presume the conformity with the regulation when the technical details are fulfilled. But in the area of AI, standardization also fulfills an important role that was also mentioned by Professor Larouche, which is like they serve as an ethical baseline. So they are going to establish actually what, for instance, stands as a trustworthy AI system, or what could be considered fair or non-discriminatory, etc. Some of the regulatory obligations that providers and deployers of high-risk AI system must comply with. And then finally, and this has been like the core of Professor Larouche's presentation, they also now have like more and more geostrategic relevance or geostrategic significance. So taking all this together, my idea is like to see like, okay, where are we in the EU in all this, and how should we read happening in the EU? So I'm going to focus on the AI Act specifically, and how it is related to what we just talked about. And one thing to take into consideration is trying to understand what kind of legal instrument the AI Act is. So as it is currently configured, the AI Act is actually like a piece for internal market legislation. So it's a piece of pure market regulation. And this is reflected in the legal basis that the European legislator has used to issue the AI Act, which is Article 114 of the Treaty of Functioning of the European Union, which is about like regulating the internal market. But while this norm is about like regulating the internal market and harmonizing national legislations, it is also a tool that can function as a proxy for exporting norms, for asserting autonomy to some extent. We will go through this, but in particular for perhaps assert its own views on AI governance globally. So what it does is then to try to embed certain political values such as trustworthiness, safety, and of course the respect and protection of fundamental rights into technical requirements. So it is adopting a model in which the hardcore of the AI Act, which is regulating high-risk AI systems, is done through delegating to standard setting, through harmonized standards that presume conformity. And that means that in that kind of a scheme, the EU, if we read a bit further than that, is trying to assert its view of AI governance to the wider world. So, and that's how I have structured somehow my presentation. So let me start with how the European Commission already asserts this in the standardization requests itself that it sent to the different European standardization organizations, which has been already mentioned, is mostly directed to CEN and CELELEC, having left ETSI a bit outside of the picture. So here, what we see is that in the standardization requests, the European Commission states that the standards should promote innovation and global cooperation, which is consistent with union values and interests. So here is already asserting that when it comes to standardization, it is important that those standards are respectful of EU values. So what would that mean, in other words, is that it is not only about technical specifications or interoperability, if we're thinking about like a more international trade perspective, which is like that one might give traditionally to standardization, but it's actually about value alignment. So this is point kind of like number one on how the EU is doing this. And this, of course, what highlights is the actual geopolitical story that we are currently living in, right? So the EU is doing that not only to lead any kind of like regulatory process, but actually to assert its position vis-a-vis the US and China. So in this context, what we could see is that the motivations, and this can be, of course, argued, but what one could see is that the motivations are both external and internal. So we find like internal and external incentives from the EU legislator slash politician, because like what we see now in the EU is a more difficult distinction between law and politics. This has been already also mentioned. So this is also reflected, of course, in these legal instruments that we have at hand. So externally, the EU wants to promote like an environment that is about like safe AI, trustworthy AI, rights respecting AI. And by doing so, it wants to counterbalance the US market dominance, but also the US kind of state-led expansion that we can see, like with the way in which China exports technology to other countries, and it's technology that can be subject for or that can be used for specific purposes that may or may not be that democratic. So internally, because we mentioned that the EU might have like internal and external incentives, internally, it's also about ensuring strategic autonomy. We all do it these days. Like I was connecting this morning in my class in the EU with US technology, right? So I was like using US slides and I was using US like devices, etc. So the EU is now more committed than it was before to reduce the technological dependence. And therefore, one way to do so is actually to keep this level of regulatory relevance. So we will come about, like Professor Larouche was talking about digital empire. So of course, like the Brussels effect still transpires from some of the EU regulatory instruments, such as the AI Act. So here what we see is that despite this regulatory ambition that the EU may have, we need to take into consideration that for that ambition to actually materialize, it needs to hinge on power, it needs to hinge on incentives and in the global adoption. And here is where standards are more visible, like a tool where the EU can actually exert that influence. So that takes me to my second point. What is the actual global landscape at the moment and where does the EU fit in all this? Since Professor Larouche made an excellent presentation of what is the current global AI landscape, I won't repeat myself into this. I'm just going to go directly into what is the role of the EU. So what we see here is that the global landscape is fractured, is unstable, more so since the elections in the US later in late 2024. So at the moment, it's not about thinking of a WTO kind of world where countries come together and then they share certain values and then we try to create some sort of free markets. So now what we have is like different competing interests and such. This is clear, so I won't detain myself into this. But when we are talking about technology, we see two important developments. On the one hand, what we see for the last decade already is a concentration of power in the hands of the private industry. So AI governance is dominated largely by US big tech, and this has been also mentioned, so I won't go into it. But most importantly, what we need to consider here is like in the participation of the industry in standardization, what we find is a normative incompatibility between the public sector's ideals of, for instance, an AI for good, the trustworthy AI, etc., and the actual realities of what these companies are bringing to the table, which is like, as academics have called, like surveillance capitalism or platform extractivism, etc. I won't go into detail, but it is important to consider that this is part of one piece of the puzzle that we are facing right now. And on the other, then we have like that the geopolitical landscape is characterized by the different postures. On the one hand, we have China, then the US, and then the EU that is trying to bring values to the governance landscape at the moment. The problem is that at this very moment, the EU is structurally very fragile, and it's structurally very fragile from many different problems. But one of them has to do with the fact that the EU, in my opinion, this cannot be shared, is struggling, especially after the Draghi report that has been already mentioned, is struggling to what to do with the current pieces of legislation that it has in place, including the AI Act, and how ours is going to act politically and geostrategically about it. So that takes me to my third point, which is like about Brussels effect. So while traditionally the EU has relied on the Brussels effect, and that model now worked well, especially in the field of data protection, but we cannot forget that we are now nearly a decade away of the GDPR. So what we have is like a situation which not only the geopolitical landscape has changed, but also the way in which the technology is shifting as well, like what was the current or the previous status quo. So the main problem that we have with AI, and that is not something that allows the EU to keep relying on the Brussels effect, is that AI works differently than, for instance, like the assumptions that we're taking into consideration when regulating data protection. And it works differently because AI moves at a very fast pace, is a very dynamic technology, and that makes enforcement very difficult, but also any kind of global agreement also more uncertain, because we've been also operating on the assumption that, especially in 2016, 2017, there were so many non-binding instruments of a global nature, right? Like principles on AI, best practices, code of conduct, etc. That is no longer on top of the agenda. Then we can see also that with the new US administration, what we have is that while the Biden administration included like stated on the leadership of the US in standardization, in the Promoting United States Leadership in Standards Act, now it seems that the situation is no longer that certain, but let's see how will that develop under the new administration. At the same time, China has been also asserting its power in international standardization fora. So the question then that becomes in all this is whether the EU will still be a global maker in the field of AI, or instead, in this case, it will have to conform itself with becoming a rule taker. So what is the EU doing? It's something that requires some analysis, but what we can look into, for instance, as I said, we will look a bit deeper, is, for instance, like, what does the EU mean when it talks about the strategic autonomy, right? And how this is reflected in the AI Act. So let's go a bit one by one. So what does the EU mean when we talk about strategic autonomy? So here, when we talk about strategic autonomy, the first thing that comes to our mind is that this raises the question of autonomy from whom and autonomy for what purpose, right? So here, as I already said, like, the EU is now a bit more politically and institutionally aware of our technological dependence. And then an example and a reaction to that has been the EU Chips Act. And here is, of course, about like securing supply chains, regaining industrial control, and of course, reducing dependence from European infrastructures. But then on the paper, while what the EU wants is to avoid that dependence and to retain some control with this this technical, but also at the same time, for the many reasons I have already mentioned before, it's also like technical, but also normative infrastructures, right? So here what we have is that on the one hand, and on the other hand, what we have is like, while that's it on the paper, in practice, what we're missing at the moment is like a specific EU-wide industrial policy that actually fosters technology development. And at the moment, with how things stand, if you talk to industry, not that I talk that much, but I've talked my share, then they're not particularly happy with how things are developing at the legislative level. But while I'm not here to assess whether the AI Act is fit or not for the purposes of fostering an European AI industry, what I want to show is, looking specifically at the legal provisions, what is the EU actually trying to do with the standardization landscape? So standardization in the AI Act is referred to in Article 40, that talks about like the necessity of specifying or defining what are the technical specifications upon which companies would then presume compliance based on the specificities of what would be the harmonized standards when they have been created. So here, the logic is that the AI Act is about like delegating this to standard setting. That is not per se necessarily good or bad. We know that in the history of standardization, while it is true that there is a risk of regulatory capture, it is true that it is specialized communities that lead standardization, and we should not look into standardization as something bad per se, because standardization, for the good part, is done because the legislator lacks expertise. And second, if you want to keep the conversation relevant, you need to see relevant people on the table, and the people who are relevant are the technical experts, not necessarily the political ones. But there is this issue that we now know and we've been discussing, which is like, by the nature of the AI Act and the specific requirements to be further specified under a harmonized standard, now some of the values that are similarly technical are going to be of a more normative or value-laden category. So how is the EU going about it? So the EU is saying that whenever there is no standard, wherever the ESOs, like European standardization organizations, have not fulfilled their duty under the standardization request to produce a harmonized standard, or where the harmonized standard does not address sufficiently the issue of fundamental rights, or where the ESO has rejected the request from the Commission, then the Commission itself will set a common specification. So that's a powerful move, because that will actually allow the EU to bypass international standardization bodies. So this is a message that, to some extent, even it can, like, being accused, I've been reading that by some commentators, I don't know if I will go that far, as a protectionist move. So wherever an international standard is not, let's say, like, accepted by EU policymaking, then a common specification will be then issued. So that is one issue. And then another issue is that then it will allow to make common specifications that will favor, to some extent, EU-based companies so that they have more likely to better compliance, and then will have, like, to some extent, the upper hand regarding how they comply with this. So while this is, like, in theory, like what all this will mean, because we still do not know, we still not have harmonized standards. They were due later this year, but they have been a prorogation for, I believe, February 2026. I would have to correct myself on this. But then in practice, what it happens is that because the EU is issuing this piece of market regulation for which the EU is very well equipped, institutionally, procedurally, but also politically, because this is the original EU market integration project, right? So which is like bringing in together certain like common technical details that would not give rise to much conflict among member states. So then there is no much debate, and then, or no much normative debate, and therefore it would be easy to come up with the specific technical details. Now with the AI Act is different, because the AI Act, as I mentioned, can be read in light of strategic autonomy, and that's big in what it means for the EU, because in this context, member states, unless they find a common position, and this was visible to some extent in the last AI summit in February in France, member states still diverge about what the strategic autonomy means. Member states still diverge about like what digital sovereignty means. It cannot mean the same, for instance, in France than it does in Estonia, the particular, right? So these are the kind of things that the EU still, like, while having like an instrument in place, which is seemingly technical, then still needs to deal with at the political level. But also the EU lacks the industrial base that could be comparable to the US or China. Professor Larouche has mentioned this already quite well, that would actually make the EU leader in standardization, because at the end of the day, the standard success will depend on the market adoption. And also a third point that is very difficult to keep when we're talking about like the EU sustaining this ambition is that the institutional tools remain incomplete. So not only the AI Act is outsourcing standardization to private bodies and ancillary, but it also is reserving some powers to the Commission in the sense of common specifications. So if that would be the only institutional landscape, okay, but then it puts together like a set of institutions that it is not yet clear how this is gonna work, because it's still like in the making. So those are my thoughts concerning the Brussels effect and the role of the EU to play in the strategic autonomy. But then let me talk about like power. So who is actually setting the standards, and what are the values that are being embedded in those standards? So as we know, standards are not neutral, particularly in AI. And they are instruments actually of power, legitimacy, and of course, normative direction based on what we already talked about. So this, of course, poses the question of like, whose values are embedded? Is there enough public oversight? That was also discussed at the end of Professor Larouche's presentation. And what is the democratic legitimacy of all these instruments, right? So here then we need to move and pay attention into what is the political economy of standardization. I will be very happy to talk about this during the questions. And then the most important is that we should not forget that now more than ever, standardization is actually redistributing power for many of the reasons that I have already mentioned. And of course, whomever has the capacity to be a relevant actor in standardization will have also like a capacity to shape even political agendas. Yeah, there are issues related to what is the public accountability of all this. So my concluding thoughts, and to keep it short, is that AI governance, and from taking the chain of thought from Professor Larouche's presentation, is that AI governance is still globally interdependent despite all the different like movements are happening at the geopolitical level. And even though the EU is trying naturally, like any other big power, to set its own standards, the actual success is actually going to depend on whether they are these standards, European standard, harmonized standards more specifically, and to speak with legal accuracy, whether these are adopted by companies and regulators outside of the EU. And here the problem is that we are facing a double constraint. The first one is that the EU lacks the industrial dominance that the US, for instance, enjoys regarding foundational models. So how is the EU going to assert this leadership in there? But second, if we look at China, then the EU cannot also try to match China's capacity to centralize and to coordinate large-scale innovation for the reason I already mentioned. It still lacks like a coherent AI industrial policy. So my concluding thought is then that the EU power is not or is not at the moment placed in its industrial scale because it's considerably or comparatively smaller to the other two focus points that I just spoke about, but it's in the normative influence. And this is why the EU, aware of this, issued the AI Act as the first regulatory instruments in the world, or so-called first regulatory instruments in the world. It's also about regulatory coherence, and it's also about the actual legal direction that the EU wants to give to all this. So with this, I now conclude. Thank you so much, and looking forward to have a discussion.
Thank you. This is the time for me to close this first panel. Thank you to our two panelists, Professor Pierre Larouche and Marta Cantero Gamito. It was really great to hear you, and I think we have very well set the stage for the other panel.